This courtroom drama takes a serious turn as Judge Fleischer confronts a defendant who just can't seem to stay out of trouble. Mr. McCollum is back in court for his third bond violation, and this time, it's not minor. Prosecutors say he turned off his GPS monitor for 3 days and violated the court's trust. On top of that, he's accused of harassing the mother of his child while she's pregnant, even allegedly trying to stir up trouble against her on social media. From the very beginning, the tension is obvious. The judge reminds him that he already warned him about zero tolerance. Third violation. Not first. Not second. Third. That alone puts his freedom on thin ice. Mr. McCollum claims the GPS device was dead and insists he didn't realize it until days later. He says he eventually received a new charger and device, but the judge isn't buying it so easily. Why wait 3 days to report it? Why not immediately contact authorities? Those unanswered questions hang heavy in the courtroom. Meanwhile, both sides trade accusations. The complainant claims harassment and intimidation. The defense pushes back, saying the accusations are exaggerated and that she's the one provoking contact. It becomes a he said, she said battle, but the judge stays focused on one thing: evidence. In a powerful moment, Judge Fleischer makes it clear that excuses don't matter. Compliance with bond conditions is everything. GPS monitoring isn't optional, it's a direct court order. And when you're already on your third violation, patience runs thin. Instead of immediately revoking bond, the judge gives him one last opportunity. He adjourns the hearing until Friday, giving the defendant a chance to bring proof about the GPS malfunction and address the allegations. But the warning is crystal clear: if the evidence doesn't hold up, jail is next. This case shows how quickly second chances can disappear. And how judges balance fairness with accountability. One wrong move could change everything.
Now we have a third bond violation. What was the nature of this violation, please?
So it's that we lost cell on it, so either it wasn't charged properly or something of the nature. It's just.
So he had a dead battery.
Yes. And
how long?
If I may, if you would be willing to admonish the defendant as well. I spoke to the complainant yesterday, and apparently the defendant has been making posts about her on social media, bribing people with money to hurt her, and she's pregnant with their child.
Judge, this complaining witness has been sending a bunch of messages to my client. She's been harassing him. I actually advised.
Show me.
I advised.
Show me.
I did ask her to send me screenshots and everything, Judge, and she said
We'll have a hearing. Show me. We'll have a hearing. Show me what you got. We'll have a hearing over it. But all I know is this is your third bond violation. I'm not happy with you, Mr. McCollum.
I saw that I don't think it turned back on at all from what I'm seeing on my end. But whenever he did report yesterday to have the device inspected, and they did just tell me that he did receive a new charger and new device.
When did it die? What's the date?
14th.
So from the 14th to today, when he got it back on, it's been dead?
He got it on yesterday, Judge.
Yes.
Well, it was on
To
yesterday.
the 17th. It's been dead for 3 days.
It was on yesterday. They called me yesterday and told me to go to pretrial and check out because
The
they gave me.
device has been dead since December 14th.
I
And
wasn't aware of that, sir. I never knew they didn't give me no text or nothing. I was unaware of picking his charger. They gave me a new charger.
Judge, with all due respect, he went there on Monday. They gave him a new charger and a new device. So it seems to me that it's a technical issue. So Judge,
you're supposed to charge it on a daily basis. Am I
Even in the pretrial, they charged it and they seen that it was charging, but it was still something messed up with the charger. So they gave me a whole new thing again.
how often is he supposed to charge it?
I think they're advised to charge once a day for at least an hour.
I'm not buying it. I'm sorry, Hunter. He goes with you. No. This is a third violation, Mr. McCollum. It's not going to continue to happen.
Judge, with all due respect,
That's with you.
this is a technical violation. He shouldn't have to go into custody.
It's a third violation, Hunter.
Second, sir.
Judge,
Second.
it's
the first
clearly,
time.
just please stop talking. Let me talk. Judge, it's clearly that there was an equipment issue. Otherwise, they wouldn't have replaced the equipment. So I don't see how.
Could be an excuse, Hunter. The minute you have an issue, you're supposed to go get it serviced, not 3 days later. This is a third stop. This is a third violation, and I told you the last time when you were here with the baby that there was absolutely no tolerance, that you were supposed to live to the condition days.
I was unaware of that, sir. So when they called me.
Goes with you. Sorry, I'm not gonna entertain excuses. It's zero
I'm not
tolerance.
giving you an excuse, sir. They gave me a new charger and a new monitor. It's
Judge.
not like I didn't mess up anything. As soon as they called me,
Talk to your attorney. Judge, would you allow me to escort him up to felony court so that he can go take his plea today? The whole reason they had set the plea to after the holidays is so that he could do it after the holidays. And I believe part of this deal would see this case go away, and he's gonna be on probation for 2 years upstairs. So I really don't see the benefit to
I mean,
society.
if you wanna go see if that's something that you guys can work upstairs, I can ask if they'll escort him upstairs, but I can't continue to play this game, Hunter.
I understand,
You know,
Judge.
I mean, really, we ask you over and over and over to comply. I'm not asking for much,
I
right?
understand,
And
Judge.
it's been dead for 3 days. You know it's been dead because you're supposed to charge it. So you're supposed to charge it on a daily basis. So for you to come here and tell me, I didn't know, it's disingenuous. It's just not true. So, but
My
I'm
frustration
happy
as
to
a
acquiesce.
attorney is I've seen this with multiple clients where there are technical issues that happen with these devices. I've seen it with multiple clients where they're unable to charge.
Hey, if you see it on the 14th that you have issues, then you go immediately. You don't wait 3 to 4 days later, especially when you've had violation after violation after violation. I think that your complaining witness may be here too. Rosette, CW may be here as well.
Judge, I'm not sure.
So, I don't know, Hunter, just,
I believe that's for a judge.
okay, ma'am, please, don't. If you wanna,
I think pretrial has something to say. I don't know what they have to
I
say.
reached out to my supervisor of these devices just because I'm not super well versed in the GPS realm, but he stated that the reports for his GPS appear to show an issue with overcharging, which can lead to a charger problem. They're instructed to charge for 1 full hour on the same time each day, and that the tech swapped his device as a precaution as it was likely that malfunctioning.
but why wait 3 days? You know the device is malfunctioning on the 14th. You're gonna wait 3 days to go get it fixed?
I was just informing of what my supervisor told me because I asked somebody to go over the report.
I don't know what to tell you,
I
Hunter.
mean, Judge, it
No.
sounds like he was overcharging. He was doing more than required.
No, we don't know that for sure. I don't know. See what documents that you can show me, that you can get, that there's some kind of malfunction. But nevertheless, it's a third violation. On the 14th, if he has issues, perhaps even go the next day, on the 15th. But you wait 3 days, and the only reason he did it is because I hauled him into court, and I told him to be here on the 18th. Otherwise, who knows what would have happened? See what you can find, and then show me. I'm all eyes.
Well, Judge, the other thing I would ask is if you are gonna take him into custody, I'd ask for a formal hearing to be set. And since this was set within less than 24 hours, I do believe it violates his due process to go ahead and take him into custody today. Yeah,
Just show me what you can find, Hunter, you know? Eddie,
Judge, real quick, Judge, I was just thinking.
save the drama for your mama. Guys, are you ready?
Yes, Judge.
There are times in life when you run into people, they can be a complete cancer to your life. Some people thrive on drama. That's how they get off. That's all they like. They like to just create. If you have people in your life like that, it's probably advisable to cut ties Because if not, they're just going to bring you down. We all have people like that in our life. We do. I do. I have people that are constantly after me as well. I do everything in my power to get away so that it doesn't bring you down. The problem is, Mr. McCollum, is when we have situations where there are repeated bond violations, I take issue with that. And I can't let people go when they continue to have violations. But I want to know that it's a true violation. I have ordered him not to have contact with this person, correct? Just, I'm not asking much from you. The only thing I'm asking you to do is stay out of trouble, keep your monitor on, and don't have contact. You stop. I'm not asking you to say, I don't like to put people in jail, but I got to know that you're complying with the conditions. There's a lot of things that are at play in your case here. There's a lot of other evidence that's out there that I would like to see before I take action and put you in. They're saying things that happen. Hunter is saying things that happen. I want to know what the truth is. And the truth is, and it lies with the evidence, because the evidence will point to whose side is correct. Words, Mr. McCollum, words mean absolutely nothing. I don't give a rat's ass about words. Evidence points to whose side is correct. I am going to give you some time, not a lot, but I'm giving you to Friday to figure out what's going on, because I want to know. Most importantly, is it the machine that's messing up? Are you truly charging it? Number one. Number two, they're saying that there's been contact. I hope not. I want to know. I want to see it. Show me what you have. Likewise, show me what you have too. I'm all ears. I'm giving you the benefit of the doubt right now. If I wasn't, I would lock your butt up right now. But I'm giving you the opportunity now to show me what evidence is out there. Show me what you're doing. I want to know, are you charging this device as it should be? There are records of this. You know what the expectation is. I'm giving you time, Mr. McCollum, and I'm giving you the opportunity. I want to see it. Likewise, I want to see in what validation they have as well. That's it. We will reconvene here Friday because I want to know what Hunter has. I want to know what they have. Is that enough time?
Yes, Judge. Friday's fine.
Do you have any questions? You know what? It's better not that you don't.
The courtroom is quiet, but the tension is obvious the moment Judge Fleischer begins addressing the defendant. This isn't a first appearance filled with confusion or uncertainty. This is a return trip. And not just any return trip, this is a third bond violation. That number matters. In the justice system, patterns matter. Repeated behavior matters. And when someone stands before a judge for the third time accused of violating bond conditions, the margin for error is almost gone. Mr. McCollum stands accused of turning off his GPS monitor for 3 full days. 3 days without supervision while under court-ordered monitoring. For someone released on bond, a GPS device is not optional. It is a direct extension of the court's authority. It tracks movements. It ensures compliance. It protects alleged victims. And when it goes silent, alarms go off, both literally and legally. The judge reminds him that he has already been warned. Zero tolerance was the phrase used before. Zero tolerance means no more excuses. No more misunderstandings. No more second chances disguised as technical issues. Yet here he is again. Mr. McCollum claims the GPS device died. He says the charger wasn't working properly and that he didn't realize immediately that the monitor had stopped functioning. According to him, he received a replacement charger and device days later. On the surface, that explanation might sound simple. Electronics fail, chargers break, devices malfunction. But when you are under strict court supervision, the responsibility shifts. You don't wait. You don't assume. You report immediately. The judge questions the delay. Why did it take 3 days? Why wasn't there an immediate call to the monitoring agency? Why wasn't there documented proof the moment the issue occurred? These aren't small details. In bond compliance, timing is everything. A delay creates doubt, and doubt, in a courtroom, can cost someone their freedom. As this issue unfolds, another layer of seriousness enters the discussion. The complainant, who is reportedly pregnant, alleges that Mr. McCollum has been harassing her. There are claims of social media posts directed at her, accusations that he attempted to provoke others against her, suggestions that he crossed boundaries he was ordered not to cross. Harassment allegations tied to a bond violation elevate the situation instantly. When a court releases someone, especially in cases involving personal disputes, strict no-contact conditions are often in place for protection. The defense pushes back. His attorney argues that the situation is more complicated than it appears. There are claims that the complainant may also have engaged in behavior that fueled the conflict. The defense suggests exaggeration, misinterpretation, perhaps even retaliation. But the judge makes it clear that courtroom decisions are not based on emotional narratives. They are based on evidence. And that word becomes the center of the entire hearing, evidence. Judge Fleischer emphasizes that words, promises, and explanations carry no weight without documentation. If the GPS malfunctioned, there should be service records, communication logs, proof of attempts to fix the issue. If harassment allegations are false, there should be digital evidence, timestamps, or witness accounts to contradict them. The court does not operate on feelings. It operates on proof. There is a noticeable balance in the judge's tone. Firm, but not explosive. Direct, but not reckless. He understands the seriousness of the allegations, yet he also understands the responsibility of fairness. Judges hold immense discretion. They can revoke bond immediately. They can remand someone into custody without delay, especially on a third violation. Many would argue that 3 strikes should mean immediate consequences. But instead of instantly ordering jail, the judge pauses the process. He adjourns the hearing. He gives Mr. McCollum until Friday to produce evidence supporting his explanation about the GPS device and to address the harassment allegations properly. This is not generosity without limits. It is a narrow window. A final opportunity to prove compliance. And then comes the warning. The judge states clearly that if he were not giving him the benefit of the doubt, he would lock him up right now. That statement changes the air in the room. It is not a threat for drama. It is a factual acknowledgement of how close the defendant is to losing his freedom. The message is unmistakable. This is the edge. Bond is often misunderstood by the public. Many think of it as a guaranteed release. But in reality, bond is conditional freedom. It is a contract between the court and the defendant. The court allows release under specific rules. The defendant agrees to follow them without exception. Break those rules, and the contract dissolves. A GPS monitor is not just a piece of plastic strapped to an ankle. It represents trust. It represents supervision instead of incarceration. When it stops transmitting, that trust fractures. Whether intentionally turned off or negligently ignored, the result is the same, a violation. The harassment allegations compound the problem. Courts take protection orders seriously, especially when a complainant is pregnant. Even indirect contact, like social media posts, can sometimes violate bond conditions depending on the language used and the restrictions imposed. Digital actions leave digital footprints. Screenshots, metadata, timestamps, all of it can become evidence. What makes the situation particularly tense is the repetition. First, violations can sometimes be corrected with warnings. Second, violations raise concern. Third, violations suggest a pattern. And patterns are difficult to defend against. Throughout the hearing, Judge Fleischer demonstrates something important about judicial discretion. He does not immediately assume guilt. He does not automatically accept the defendant's explanation either. Instead, he places the burden where it belongs, on proof. If you claim a device malfunctioned, show it. If you deny harassment, prove it. Courtrooms are not arenas for storytelling. They are arenas for substantiation. The narrator observing this situation might believe the defendant is not being truthful. Skepticism naturally grows when explanations seem delayed or incomplete. But what stands out most is the judge's measured control. He neither explodes with frustration nor shrugs off the seriousness. He keeps the focus narrow: compliance, documentation, accountability. There is also a deeper lesson here about consequences escalating over time. Judges remember prior warnings. They remember when they said zero tolerance. They remember when they gave second chances. And when someone returns yet again, the tolerance shrinks. By adjourning the case instead of revoking bond immediately, the judge sends two simultaneous messages. 1. Fairness matters. 2. Patience is nearly exhausted. The next hearing will be critical. If the defense produces service logs proving the charger failed and that replacement equipment was requested promptly, that changes the narrative. If communication records show no prohibited contact, that weakens the harassment claims. But if documentation is thin or non-existent, the judge's earlier warning may become reality. Freedom before trial is fragile. Many defendants underestimate how strict bond conditions truly are. Missing a charge, ignoring a call, failing to report, small oversights can spiral into custody. And when supervision includes GPS monitoring, the expectation is constant awareness. The courtroom scene becomes less about drama and more about accountability. It becomes a reminder that court orders are not flexible guidelines. They are commands backed by authority. As the hearing concludes for the day, nothing is fully decided. There is no dramatic ending. No immediate handcuffs. Just a ticking clock toward Friday. Evidence will determine the outcome. Documentation will shape the judge's next move. And hovering over everything is that one unmistakable reality: third chances are rare. Fourth chances are almost non-existent.